Hello everyone, welcome to the USA Visa Tracker. Today we are covering a topic that has sent shockwaves through the entire US immigration community. And if you are a green card holder or you know someone who holds a green card, this video is absolutely essential for you to watch. There has been a major shift in how the United States government is approaching permanent residents, and the implications of this change could affect millions of people already living and working in this country. We are talking about the new immigration enforcement and review policies that have come into effect in 2026, and these changes are putting green card holders in a position they have never been in before. If you are interested in this topic and liking this video, please stay tuned until end of the video. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now, let's get into the video. For years, green card holders in the United States have operated under the assumption that once they received their permanent resident status, their position in this country was largely secure. A green card, officially known as a permanent resident card, has long been considered one of the most stable forms of immigration status available. It allows individuals to live and work in the United States indefinitely, travel abroad and return, and eventually apply for naturalization to become a U.S. citizen. However, in 2026, the landscape of permanent residency has shifted in ways that many immigration experts and legal analysts did not anticipate. The United States government has introduced a series of new enforcement measures and policy reviews that are directly targeting green card holders, and the reasons behind these changes are rooted in broader immigration enforcement priorities set by the current administration. So what exactly has changed and why should green card holders be concerned? Let's take a closer look. In a recent development, Immigration and Customs Enforcement, or ICE, along with the United States Citizenship and Immigration Services, known as USCIS, have announced a new wave of reviews specifically aimed at permanent residents who fall into certain risk categories. These reviews are not random. They are being conducted based on a set of criteria that the government has established, and understanding these criteria is critical for anyone holding a green card right now. The first major change involves an expanded review of green card holders who have criminal records, even for minor offenses. Previously, many minor infractions did not automatically trigger a review of someone's permanent resident status. However, under the new guidelines, USCIS is now conducting a much broader sweep that includes misdemeanors, violations, and even certain civil infractions that were once considered insignificant. Immigration experts note that this expansion of criteria has caught many people off guard, particularly those who received their green cards years ago and may have had minor issues on their record that they believed would never come into play. The second significant change relates to public charge determinations. The public charge rule, which evaluates whether an individual is likely to become dependent on government assistance, has been strengthened and is now being applied retroactively in certain cases. What this means is that green card holders who have used specific government benefits, including certain forms of public assistance, may now face additional scrutiny. This does not mean that every green card holder who has used government programs is automatically at risk, but it does mean that the bar for what is considered acceptable has been raised considerably. Legal analysts suggest that individuals who have relied on programs such as Supplemental Security Income, or SSI, or certain housing assistance programs should consult with an immigration attorney as soon as possible. The third area of concern involves background check enhancements. The government has implemented a new system of continuous monitoring for permanent residents, meaning that criminal background checks are no longer limited to the point of application or naturalization. Reports suggest that this monitoring system is being used to flag individuals who may have had legal issues arise after they received their green card. This is a fundamental shift in how the government tracks and monitors permanent residents, and it represents a level of ongoing oversight that did not exist in previous years. Now, who exactly is being affected by these changes? The categories of green card holders who are most at risk include several distinct groups. First, there are those who obtained their green cards through family-based immigration petitions, such as the I-130 petition, and who may have had minor criminal issues surface after their approval. Second, individuals who are in the process of applying for naturalization and who have criminal records, no matter how minor, are being advised to proceed with extreme caution. Third, green card holders who have been outside the United States for extended periods and who may have had changes in their personal circumstances, such as new income sources or changes in family status, are being flagged for additional review. And fourth, those who obtained their green cards through employment-based categories, particularly EB2 and EB3, are facing increased scrutiny if there are any discrepancies between the information they provided on their original petition and their current situation. But what does this mean for the everyday green card holder who has been living peacefully in the United States, working, raising a family, and simply trying to build a life? The truth is that for the vast majority of permanent residents, these changes will not result in any immediate action. However, the concern is not just about what is happening today. The real question is where this trajectory is heading. Advocacy groups warn that the current policies represent a slippery slope and that the criteria for review could be expanded even further in the coming months. In a recent statement, officials from USCIS clarified that the intent of these measures is not to create fear among lawful permanent residents, but rather to ensure that individuals who hold green cards are in full compliance with all immigration requirements. The administration claims that these changes are part of a broader effort to maintain the integrity of the immigration system. However, critics and legal experts have pushed back strongly, arguing that the broad nature of these reviews is disproportionately affecting certain immigrant communities and that the retroactive application of the public charge rule raises serious legal and constitutional questions. Despite these challenges, there are steps that green card holders can take right now to protect themselves. The first and most important step is to review your own record thoroughly. If you have any prior criminal issues, even ones that you believe were minor or that were resolved years ago, you need to speak with a qualified immigration attorney. Do not assume that something in your past will not come up during these new reviews. The second step is to gather and organize all of your immigration documents, including your green card, any approval notices, tax returns, and records of any government benefits you may have received. Having these documents readily available can make a significant difference if you are contacted by USCIS or ICE. The third step is to understand the difference between adjustment of status and consular processing if you have family members who are currently in the immigration pipeline. The processing times for certain visa categories have also been affected by these broader enforcement priorities. Reports suggest that processing times for family-based immigrant visas, including the CR1 and IR1 categories, have increased by an estimated 14 to 16 months in certain cases, as resources are being redirected toward enforcement and review operations. In addition to these individual steps, many immigration advocacy organizations have begun filing legal challenges against certain aspects of these new policies. While it remains to be seen how quickly these challenges will move through the courts, they represent an important counterbalance to the enforcement measures currently in place. Legal analysts suggest that some of the more aggressive aspects of the policy, particularly the retroactive application of the public charge rule, may face significant judicial scrutiny. Beyond green card holders, the administration has also signaled that similar review processes could be extended to other categories of immigrants, including those on long-term work visas such as H-1B and L-1 visas. While no formal announcement has been made regarding these categories at this time, speculation suggests that the groundwork is being laid for a more comprehensive overhaul of how the United States government monitors and evaluates all categories of immigrants currently in the country. Some reports indicate that holders of student visas and certain temporary protected status designations may also face increased scrutiny in the months ahead, though official confirmation of any such expansion has not yet been provided. What makes this broader enforcement climate particularly significant is the way it is affecting pending immigration cases across the board. Individuals who are currently in the middle of the green card application process, whether through consular processing at a U.S. embassy abroad or through adjustment of status within the United States, are reporting longer wait times and additional requests for evidence, commonly known as RFEs. An RFE is a notice from USCIS asking the applicant to provide additional documentation or information to support their case. The number of RFEs being issued has reportedly increased by a significant margin compared to previous years, and immigration attorneys are noting that the requests are often more detailed and demanding than they used to be. This is adding considerable time and stress to an already lengthy process for many applicants. Additionally, for those who are sponsoring family members through Form I-130, the petition for alien relative, the processing environment has become more unpredictable. Sponsors who have criminal records or who have had any issues with immigration compliance in the past are being asked to provide more documentation up front. And in some cases, petitions that would have been approved in previous years are now being held for additional review. This is not just affecting the sponsor, it is directly impacting the family members who are waiting abroad for their visa to be approved and for their family to be reunited. Another important development that has emerged alongside these policy changes involves the coordination between ICE and local law enforcement agencies. In several states, local authorities have begun sharing information with federal immigration officials at a much higher rate than in previous years. This means that a green card holder who has an encounter with local police, even for something as minor as a traffic stop, could find that information being flagged and reviewed by federal immigration agencies. This level of interagency cooperation has drawn significant criticism from immigrant rights groups and some state governments, who argue that it creates a climate of fear and discourages immigrants from seeking help from local authorities when they need it. However, the administration maintains that this cooperation is essential to enforcing immigration law effectively, and that permanent residents with nothing to hide should have no reason for concern. To put this in perspective, consider the experience of green card holders who have been in this country for 10, 15, or even 20 years. Many of these individuals have built entire lives here. They own homes, they run businesses, their children were born in the United States and are American citizens. For these individuals, the idea that their permanent resident status could suddenly come under review based on a minor issue from years ago is not just unsettling, it is deeply destabilizing. Immigration experts note that the psychological impact of these policies extends far beyond the individuals who are directly targeted. Even green card holders who are in full compliance and have clean records are reporting increased anxiety about their future in this country simply because of the broader enforcement climate. There is also the matter of how these changes interact with the naturalization process itself. For green card holders who have been eligible to apply for citizenship, the Form N-400, which is the application for naturalization, has always required full disclosure of any criminal history. Under the new review guidelines, USCIS is now cross-referencing the information provided on naturalization applications with data from the continuous monitoring system, which means that any discrepancy, no matter how small, could result in a denial or, in some cases, a referral for further immigration proceedings. This has led many immigration attorneys to advise their clients to delay naturalization applications until they have had a thorough review of their entire background and have resolved any outstanding issues. For those who are considering applying for naturalization in the near future, this situation might feel overwhelming. The path to citizenship has always required a clean record and full compliance, but the definition of what constitutes compliance has clearly expanded. Immigration experts note that individuals planning to apply for naturalization should allow extra time for preparation, ensure that all prior issues have been fully resolved, and consider consulting with an immigration attorney well before submitting any application. In practical terms, what this translates to is a heightened need for awareness and preparation among the green card holder community. This is not a time to panic, but it is absolutely a time to stay informed and take proactive steps to ensure that your status remains secure. The United States immigration system has always been complex, and navigating it successfully requires knowledge, preparation, and in many cases, professional guidance. That's all we have for this bulletin. The USA State Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas, such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the channel for more U.S. immigration update videos.